Creato's already served. Secondly, although again realizing this is up to the Bureau of Prisons, because of proximity to his immediate family, I would ask that the court recommend to the Bureau of Prisons, to the extent that it's cable, that Mr. Creato serve his period of incarceration at Southwood. Other than that, Your Honor, though, I just ask that the court impose the negotiated sentence as already agreed. I've discussed with Mr. Creato his right to elocution. He's declined to make any comments.
I am going to ask you. I'd ask that Mr. Creato please rise. So is there anything you wish to say to me before I impose that? No. All right. Before me this afternoon stands David Creato, a 24-year-old individual who had guilty of count 1 of this indictment, which is amended to aggravated manslaughter, a crime of the first degree. The defendant's plea resulted from an agreement with the prosecutor. The defendant has waived his right to appeal. The court has reviewed the criminal division's pre-sentence report. It finds that this defendant has had prior contact with the court system, having incurred 1 municipal court conviction. The present offense represents the defendant's first felony conviction. This indictable conviction, the court finds the following aggravating factors. Number 2, in my analysis, I agree with the prosecutor to the extent that, while aggravating factor number 2 is typically not found in light of a double counting because of the nature of the crime itself. In this case, and as that aggravating factor comes down, extreme youth is a consideration that can come into play, and I think that's separate and apart from the gravity and seriousness of the crime. Accordingly, I do find aggravating factor number 2 does apply. The state urges I find aggravating factor number 3. Based upon the totality of the circumstances, I cannot find that as an applicable aggravating factor. The state also urges aggravating factor number 9, the need for deterrence. And I do find that aggravating factor number 2 is applicable and must be weighed very heavily in this particular matter. I reviewed all of the mitigating factors, and I do not find that after analyzing each and every one of the 13 mitigating factors that any of those factors are applicable in light of this particular offense. Therefore, at this time, in weighing the aggravating and mitigating factors on a qualitative as well as quantitative basis, the court finds that the aggravating factors outweigh any mitigating factor, whereby the period of parole and eligibility statutorily will be imposed. This was a negotiated plea agreement between the prosecutor and the defendant. Deciding whether or not to accept the plea agreement, the court considered the nature and degree of the crime, the need for punishment and deterrence, the defendant's prospects for rehabilitation, confidential information contained in the pre-sentence investigation report, the defendant's previous involvement in the criminal justice system, the recommendations of the prosecutor, the terms of the plea agreement, and the interest of the public. The plea agreement appears to be fair and in the interest of justice, and the court will sentence the defendant in accordance with that agreement. Accordingly, sir, pursuant to count 1 of this indictment as amended, and sentence you to a term of 10 years to be served in New Jersey State Prison. As your counsel indicated, I do not control where you would be placed for purposes of completing this sentence. That is a decision made by the Department of Corrections. However, I have no problem in recommending that you be sent to the Southwood facility. As I indicated, it is a 10-year term to serve in New Jersey State Prison. That is subject to the No Early Release Act, which mandates that 85% of that sentence must be served before you would be eligible for parole. That 85% of 10 years does equate to 8 years and 6 months. Upon your release, you will be supervised by the Bureau of Parole as equivalent parole for an additional period of 5 years. You will be responsible for providing a DNA sample and responsible for the following financial obligations. There is a $100 violent crime compensation board assessment, $75 Safe Streets and Safe Neighborhood penalty, and a $30 legal assessment. You are, pursuant to court rule, entitled to all lawful jail credits, which in this instance I do calculate to be 627 days, those being from January 11, 2016 through yesterday's date. At this time, I am dismissing count 2 of the indictment as against you. All fines and penalties will be transferred to the New Jersey Department of Corrections for collection as part of any parole which may be granted. Finally, sir, I must advise you that you do have 45 days from today to appeal your conviction and sentence. If your private attorney does not continue to represent you on appeal, you or your attorney should contact the Criminal Division Manager's Office to apply for a public defender. If you cannot afford counsel, the Public Defender's Office would represent you. If you miss the 45-day deadline, you may ask for a 30-day extension to file the appeal. You can show the reason for missing the deadline. If you miss the extended deadline, you lose your right to appeal. Do you have any questions about your right to appeal? would have 5 years from today's date to file a petition for post-conviction relief, unless an exception to the general rule applies as is set forth under our Court Rule 3:22-12. Did you discuss the notice of appeal at the time to file a petition for post-conviction relief with your attorney? Did you sign the form that says forth those rights?
He's not signed the form, you don't have him sign it.
All right, I'm going to ask that you sign that form, and upon signing that form, I will be satisfied that you knowingly and intelligently have executed that form and clearly understand your rights regarding the notice of appeal, as well as your rights regarding filing any petition for post-conviction.
Judge, may I ask the court, I think Your Honor may have misspoken when you made your findings. You were speaking about aggravating factor 9, but then when you indicated great weight, I think the court said aggravating factor 2. Can I just have a clarification on the weight that was given to aggravating factor 9?
Great weight.
Thank you.
And the aggravating factors I found were 2 and 9.
Thank you, Judge.
All right. Thank you.